Hello and welcome to the LaWisdom. Today we are going to discuss one of the most important case which I have been really closely watched that, and I am getting connected with that case somehow, and I have been observed and worked on that case also. Recently, Allahabad High Court Lucknow bench denied bail to 34 constables in Pradeshik Armed Constabulary (PAC) who have been accused of killing 10 Sikh men in alleged fake encounter in 1991, treating them as terrorists. The bench of Justice Ramesh Sinha and Justice Brij Raj Singh observed that accused cops had indulged in barbaric and inhuman killing of innocent persons by calling them terrorists. More so, if some of the deceased were involved in an anti-social activities and criminal cases were registered against them, then two procedure established by law should have been adhered to bring them to ask and not indulging in such a barbaric and inhuman killing of innocent persons in the name of terrorist by the appellants. The court stressed, as it listed the criminal appeal of accused filed challenging their conviction of final hearing July 25, 2022. So look at the background of the case in brief. As per the prosecution case, on July 12, 1991, a bus containing passengers, pilgrims, was stopped near Pilibhit at about 9 to 10 am by a team of UP police of district Pilibhit, as appellant said. They alighted 10 to 11 Sikh youths from the pilgrims bus, boarded them in their blue colored police bus, and some police personnel sat in the bus along with the remaining passengers, pilgrims, PW11, PW13, children, ladies and old man. Thereafter, the remaining passenger pilgrims kept roaming the pilgrims bus the whole day here and there with the police personnel, and after that the policemen left the bus in a Gurudwara in Pilibhit at night, whereas 10 Sikh youths who were alighted from the pilgrims bus were killed by the police personnel, showing them as a terrorist. By dividing them into three parts, 3 separate FIRs were lodged implicating policemen for killing 10 young men. The 11th one was child whose whereabouts would not be traced out, and his parents were given compensation by the state. Initially, the investigation of the incident was conducted by the local police of district Pilibhit, and a closure report was filed by the local police. However, the SC entrusted the investigation of the incidents relating to the so-called encounter to the CBI. The trial took place in the court of the Special Judge CBI or Additional District Judge Lucknow, and by its judgment and order dated April 14, 2016, in total 47 persons were convicted under sections 120B, 302, 364, 365, 218 and 117 IPC, Indian Penal Code. Feeling aggrieved by the aforesaid conviction and sentence, all the 47 convicts appellants moved to the High Court. Out of these 47 convicts, 12 convicts were granted bail by a coordinate bench of the HC High Court, either on the ground of age or severe ailment. Now the court had to deal with the bail pleas of 35 people. It was their primary contention that 4 of the deceased belonged to the terrorist outfits, namely Khalistan Liberation Army. There was a vigilance report that hardcore terrorists of Khalistan Liberation Front were present in Pilibhit and adjoining area, and they were committing heinous crime like murder, loot, land grabbing, etc., and have created panic in public. Look at the High Court's observations. Having analyzed the evidence on record and the arguments for both sides, the court observed that it was a case of gruesome murder of the deceased who had no criminal antecedents, along with the some of the deceased who had criminal antecedents. However, the court added that it was not justified on the part of the accused person to treat all the deceased to be the terrorist by separating them from their wives and their children who were going on a pilgrimage on the bus and taking them to another bus and killing them in a fake encounter at 3 different places of district Pilibhit. Taking into consideration the facts and circumstances of the case and also considering the gravity of offense, evidences of the prosecution witnesses, presence of 2 eyewitnesses, PW11 and PW13, who supported the prosecution case. Medical evidence corroborates the prosecution case. Non-explanation of the injuries of mark of rub and lacerated wounds found on the dead bodies of the deceased person by the appellants. Non-explanation of mark of bullet on the blue-colored bus by which eyewitness PW11 and PW13 had stated to bring 10 young Sikhs by the police personnel. Non-explanation of source of inputs gathered with regard to travelling of terrorists from the pilgrims bus by the appellants on the date of the incident. The court do not find it a fit case to enlarge the appellants on bail. The court held. Consequently, the court denied bail to 34 cops and clarified that the observations made by it were only to decide the question of grant of bail and shall not be treated to be the expression of any opinion on the merits of the case. Thank you.